Good morning, ladies and gentlemen, and welcome. My name is Kian Kim, and as same as past 2 days, I'll be the host for the 7th International Conference on the Law of the Sea. First, I'd like to thank all of your interest and support that you have shown for this conference, and we have Session 5 and Session 6 lined up for you today. Before we begin, I'd like to inform you that this conference is taking place in a hybrid format. As some of our participants are joining us online, I kindly ask your understanding for any interruptions associated with technical issues. And now we'll begin the Session 5 under the title, Voices of the Next Generation, and Sir Michael Charles Wood from 20 Essex will be the moderator for the session. Good morning, Sir Wood.
Good morning, and good morning to everybody. Clearly, I'm not a voice of the next generation, perhaps a voice of the first generation, since together with some others here, I was at the most of the sessions of the Law of the Sea conference that led to this convention. Anyway, for the session 5, we have what are called voices of the next generation, but they're actually voices of the present generation because they've all written extensively on the Law of the Sea and on other subjects. So without more ado, I'll give them the floor. They'll speak in the order in which they're set out in the program. So firstly, it'll be Dr. Nong from the Institute for China-America Studies, which is based in Washington, followed by Dr. Daun, I've got to get the pronunciation right, Dr. Daun Jung, from the NUS Center for International Law, which unsurprisingly is in Singapore. And then thirdly, and joining us online, will be Professor Shuizhi Liao. Welcome. We're sorry you can't be with us here in person, but it's very good that you're here. And then lastly, Dr. Omri Sender from Tel Aviv, who will be the last speaker. They will each speak for about 15 to 20 minutes. It's quite a short session, so I don't think there will be very much time for questions and answers, but if anyone does want to ask a question, they would be very welcome at the end. So without more ado, Dr. Nong, please.
Thank you very much, Chair, and good morning, everyone. And I would also like to join other speakers in thanking Korea Ministry of Foreign Affairs, ICLOS, and also Korea Society of International Law. I really appreciate this opportunity to include me in this program, which gave me a good opportunity to travel back to Asia since late 2019. It's my first trip back to Asia. So I really appreciate this opportunity to connect and also reconnect with so many distinguished scholars in the Law of the Sea community. When I asked to join this panel, it took me some time to figure out and do some brainstorming. What should I be talking to contribute to discussion of this panel? I feel a little bit ashamed, and I'm not quite sure I belong to the next generation. I'm not young anymore, but I would like to try to do my best to find an angle to talk about this issue and then relate it to the effectiveness of UNCLOS. So after I review all the ocean-related activities and also the regional, when I say regional, I'm referring to the South China Sea, all these Law of the Sea community are doing. So I realized that every country is busy with, for instance, on fishery management, on on shipping issues, on marine environment protection, and also been very actively participating in many of the negotiation processes such as BBNJ. So, and then I realized after reviewing, I think it makes more sense if I want to talk about effectiveness on UNCLOS, particularly with regard to a dispute settlement mechanism in the South China Sea, because this is the area, as we hear from yesterday, it's the most complex in terms of legal dimension with also political dimension as well. So that's why I chose this topic. So, so let me start with the overall ocean governance and the state practices in the South China Sea, I think it makes more sense before jumping directly to evaluate or assess the effectiveness of dispute settlement in the South China Sea. Because, for instance, when looking at ocean governance in this region, we review the state practices or the coastal state in this region, you will be realizing they're very actively in participating or ratify many of the ocean-related international treaties or regulations in various fields of fishing and environment protection, etc. And in addition to that, they also have a good reputation of harmonized national legislation in accordance with the international treaty they're being a party to. And then in terms of policy, we're looking at ocean governance. In terms of policy, we're looking at, for instance, in the South China Sea, we have issues of fishing conflicts because of pending maritime delimitation, overlapping maritime jurisdiction. And then we have a temporary arrangement on oil and gas development according to Article 83 of UNCLOS. And certainly we're looking also many of the shipping regimes on UNCLOS that's applicable in the South China Sea. And certainly there are a lot of ongoing debate on marine environment protection in this region. And lastly, I think it also makes sense to look at how the dispute management under the framework of UNCLOS in this region. So you can see from these slides, in addition to many of the political documents which does not have legal binding forces, for example, we have this DOC and also the Treaty of Immediate Incorporation in Southeast Asia. I think it makes more sense to discuss the role of UNCLOS in providing an overall framework for ocean governance in this region. So UNCLOS is result at a package of details and maintaining a delicate balance of different interest groups. So it's not intended to be comprehensive in a way that no further law is needed. So this means that although UNCLOS make use of sort of like vagueness, ambiguity, and silence at certain points on some certain types of controversial matters, it could be regarded as a very legally effective to the extent that provides systems within which to address substantial issues in this region. So the goal of UNCLOS is to provide assistance of governance rather than to deal with all the substantial matters. So, for example, when we look at the UNCLOS provisions, in almost 70 of the provisions, it refers to the possibility that subject in question may have to refer to other international instruments, bilateral or multilateral, anterior or posterior. So it is, I think, in the South China Sea, I think, in addition to recognize the importance of UNCLOS in providing a framework of ocean governance, it is also the coast states who assume a larger share of responsibility responding to many of the global problems of ocean governance confronting them. And it's also the state's responsibility to follow with implementation of individual provision of UNCLOS in various forms, such as national marine legislation, ocean governance, etc. So as I said, the South China Sea has quite a good reputation of following the general framework of ocean governance. So let me move to, so by having said that, I think it's worth mentioning that when we evaluate UNCLOS in managing the dispute in the South China Sea, I don't see it's a very clear positive answer on this issue for the very well-known reasons. So when we look through the existing practice of litigation or arbitration, they actually shows that the manner and approach concerning interpretation and application of some provision of UNCLOS need to be carefully reviewed. So one example, for instance, in the South China Sea arbitration case, which you heard already from yesterday, there's some issue which was debating, particularly, for example, when reviewing Article 288 on the procedures where no settlement has been reached by the parties, and also Article 282 on the obligation under general regional and bilateral agreement, and also Article 283 on obligation of exchange views. Also, on this case, even China, I have to put back my Chinese scholar's hat to explain, although I think on these three particular provisions, although China is not a party and chose not to be a part of this proceeding, but it does provide a lot of legal explanation why it questioned these three provisions. And certainly to Article 298, it's also controversial issues. And we heard from yesterday, it's give you an opportunity for the country to opt out of the compulsory dispute settlement, but certainly there is way to move around on this Article 298. Now, I would like to share my slides when I try to evaluate the UNCLOS dispute settlement mechanisms and its applicability in the South China Sea. So I want to emphasize that the way of preference given to different sources of international law in jurisprudence. So there are three pairs of sources of international law, namely between the old treaty and new treaties and customs, and also existing treaties and emergent treaties. So in terms of the old relationship between old treaties and new treaty, I'd always like to refer to the Arctic region, where the 1925 Svalbard Treaty and the 1982 UNCLOS they are becoming a source of conflict or difference position between Norway and other countries who are party to both treaties. And another example to show that the preference given to different sources of international law is Antarctic treaty system may be influenced by the new instrument arrangement made by BBNJ negotiation process, which reflect the importance of ensuring an emergent treaty will not interrupt jurisdictional established treaties. And then I really want to talk about is the relationship between the treaty and also customary international law. So the question of whether ratification of UNCLOS will derive coastal states' claim historical right, it is one of the major issues addressed by the arbitrary tribunal in the South China Sea, and also a typical example of the weight given to treaty and also weight given to customary international law. So although many important legal issue existed in the South China Sea, for example, island states, marine environment protection, etc. But the major legal issues in this region is the relationship of UNCLOS as a treaty law and also historical rights as a customary international law. So however comprehensive the UNCLOS is and also however significant that UNCLOS has its status, it cannot and actually does not distinguish or supersede all other historical claims, maritime claims existing under general international law. So I think I have to admit the fact that the scope and the contemporary relevance of historical claims were significantly restricted by the South China Sea Arbitration Tribunal, which found that UNCLOS supersedes any previous historical titles or rights apart from those especially recognized on Article 10, Article 15 of UNCLOS. So when we refer to historical rights and then relating to a particularized regime, that reflects a continuous and long-established and undisturbed situation. So they should be addressed case by case. I think this is the issue actually rose a lot of discussion on that. In the South China Sea. So I think what's important when we're talking about the effectiveness of UNCLOS in the South China Sea, I think what matters most for China and also other coastal states is to find a balance between the new maritime regimes such as EEZ stipulated by the Lausea Convention and also as a treaty law, and also balance with the historical concept, whether it's historical title or bay or waters, and recognized as customary international law. I even couldn't read my own slides from here. So there's a couple of issues that I want to discuss when we look at South China Sea arbitration. So the first question I want to discuss, what does the arbitration case mean for the legal order and the development of the South China Sea? So when we look at what's happening right now in the South China Sea, it's sort of like given an impression becomes the nightmare, given that there are the regional issues between or among the claimant states has been involved to a legal and also political issue, which is dragging more and more other countries, other actors in this region. So then when we see these arbitrary tribunal, the war in 2016, maybe in the short term we will see that many of the cooperating projects has been postponed, but in the longer term we see a clarity of many legal issues in this region, but it does not actually solve the real problem in this region. And the second question I want to ask, what is arbitration case imply for Article 298? I think the meaningful significance of Article 298 actually gives a country and also encourages countries to ratify the Law of the Sea Convention because it protects you from being dragged into any compulsory dispute settlement mechanism which you might not feel comfortable to deal with in terms of sovereignty or maritime delimitation and military activity as well. So in the future, I'm not quite sure whether other countries, for instance, the United States, when it consider its process of ratifying Law of the Convention, even though you can make a declaration under 298, but there's always some room to play around to make the Article 298 out of the picture. This is one concern. And the other issue is the inquiry for the future development of the four judicial body under 287. So when I look at the four judicial bodies under 287, so thank you very much. So even though we're having more cases sitting in ICLOS, 30 cases right now, I think most of the cases, as we heard from yesterday, it's about pump release and also about provisional measures and also advisory opinions. And the only 3 cases sitting in the ICLOS is on maritime delimitation, like case 28 and case 23 on Ghana and Cote d'Ivoire, and also case 16 between military delimitation between Bangladesh and Myanmar. So when I read this history of this Article 286, I personally assume that ILO will get more important cases than other judicial bodies. But the current situation shows the tendency that because when the dispute country, when they involve in a dispute, maybe they are not chose the same procedures or they not made agreement to which procedure they're going to apply to. So many of the important cases go to arbitration tribunal, which is sort of like concerning. I think like ICLOS should actually deserve more important cases, particularly on the maritime delimitation. And then the other issue is, thank you for bringing this one to me. What does South China Sea arbitration case imply for the interplay of international law and public complaint for public relations? This is go beyond talking about only the legal implication. I think what impressed me most is from 2013 until 2016, even today, like 6 years after the award was awarded, I think we have a lot of political implication than the legal implication in this region. So it tends to be more or less like a complaint between legal battle and also public campaign for public relations. And then there is another issue I want to also mention is what does the South China Sea arbitration case imply for the compliance systems? And we heard from yesterday, this is really an issue that deserves a lot of attention. And then the last point I want that I learned a lot from following this case starting from 2016 until today. I think what does this case tell about China's future position on the compulsory dispute settlement mechanism in dealing with its maritime issue? I think it's a learning process. I think although China has invited a lot of criticism in the very first place that it does not choose to participate in this procedure, but I think it's a learning process for China. There's a lot of issues that you have to bear in mind for a country like China. It has South China Sea. It actually have more significance in terms of its territory integrity and also maritime delimitation. But I think when I look through the current practices in this region, I think there's not a single answer. In the future, I think it will be too simple to jump to the conclusion that China does not want to or to be bound by the compulsory dispute settlement. I think the option is there as long as you are more comfortable with whether you have your own legal personnel capability will strong be enough. I think there was certainly an answer, an open answer on this. And also when I look at the students community in China, I realize that more and more international law students chose the law of the sea as the research focus, which is very cheerful and also very beneficial for China. And when looking through all this process of evaluating the Law of Sea Convention in this region. With that, I will finish my presentation. Thank you very much for your attention.
Well, I thank you, Dr. Hong, very much for that very interesting talk. It's certainly true that there are a lot of Chinese students in the law of the sea, not only in China, but all around the world, which is an excellent thing.